Right, we'll get going. So we've got an action-packed session today. I'm David Gebrand, head up the data privacy practice. A really warm welcome to the session today. It's the second of 3 summer sessions where we're focusing in on some key data and data privacy issues that affect businesses and organizations. And I think data privacy is a topic that is relevant to all businesses. As we transition to a world where we're increasingly focused on data. So during the data privacy summer sessions, you will hear from our experts across the firm in relation to a number of data protection and data privacy issues. And hopefully we will offer experienced view and practical insights into these. The first session was a few weeks ago. We took the opportunity to look back at the first 2 years of GDPR and to consider topics including ICO's enforcement action, lessons learned during COVID and coming out of lockdown, the importance of data privacy impact assessments and cyber security. So if you missed that one, that's available as a recording. You can view it at any time, and it's available on our websites and usual social media channels. Today, we're going to build on that session and we're going to look at some key regulatory updates and considerations that all businesses should consider when, particularly in light of the recent Schrems II decision that has hit the data privacy headlines over the last few weeks. So we'll cover that. A reminder that we're recording this session, so if you could just ensure that you're on mute as we're going through it. There will be an opportunity at the end to ask questions. And if you've been on with us before, you'll know there's a chat function. So please feel free to add your questions in the chat function, and we'll hopefully pick them up as we go through. So I'm joined today by 3 fantastic speakers from our data privacy team who'll guide you through some recent and topical data privacy issues. Hannah, can you say hi? Hi, Hannah.
Hi, Hannah. No, hi, David. Morning.
Hi, thank you. Hannah's going to look at the international data transfers and some of the practical implications from the recent Schrems decision. And we have Scott as well. Hi, Scott.
Hi, all. Morning.
Good stuff. Scott is going to look at the very important area of e-marketing, which is becoming increasingly important, I suppose, in this data-driven age as we're all moving to mobile-first business generation and brand building. And finally, Sarah Curran.
Hi, everyone.
Hi, Sarah. Sarah is going to look at some regulatory issues and best practice associated with data sharing. So when pulling together this session, I think it's clear that we're covering a lot of different topics, and probably each of these topics would justify an individual session in their own right. So we might not be able to cover absolutely everything today, but what we will do is, if there's some common themes and questions, we'll look to run further sessions, maybe more detailed sessions on these in the next few months. So first of all, let's start off by looking at the recent Schrems II case that's been hitting the headlines and what it means in practice for our businesses. So Hannah, why don't I start by summarising what the decision is, some key points anyway, and then you can talk us through some more of the detail, if that's okay.
That sounds good.
Great stuff. So European Court of Justice decided recently that the controller to processor standard contractual clauses are valid, which is good news, but that the EU to US privacy shield is no longer a valid adequacy instrument to enable personal data transfers to the US, mainly because the US's state surveillance powers are being deemed to be excessive. So businesses solely relying on the privacy shield to transfer data to the States will need to look at another option going forward, including putting in place standard contractual clauses. But there are implications for the use of standard contractual clauses as well, which we'll no doubt get onto. So Hannah, before we kick off, can you take us back to basics and maybe take a couple of minutes to think about what are standard contractual clauses and privacy shield, and why are they relevant to businesses?
Yeah, no problem. So I think if we take it right back to basics, the GDPR essentially prohibits transfers of personal data to countries outside of the EU. as it assumes that such countries do not offer an adequate level of protection to personal data. Now, as we all know, that's not exactly practical, so the GDPR permits transfer to third countries as long as appropriate safeguards are put in place to protect the transfer. Now, firstly, there are a small number of countries which have been given an adequacy decision by the European Commission, which is essentially a finding that the laws of these countries offer equivalent protection to the GDPR. These include Japan, New Zealand, Canada, Switzerland, to name a few, and transfers to these countries do not need any additional appropriate safeguards. So for those countries that do not have an adequacy decision granted in their favour, organisations wishing to transfer data to those countries from within the EU would need to put in place appropriate safeguards. One of these is the European Commission's standard contractual clauses, which organisations were, until now, able to leverage in order to effectively guarantee an adequate level of protection through a binding contract, which places certain obligations on the receiver of the data. Now, in relation to the US specifically, a framework was set up in order to allow US companies to effectively bypass standard contractual clauses or binding corporate rules requirements. This was a system whereby US companies could certify that they offered a specific level of protection when receiving data from the EU. The first iteration of it was Safe Harbor, which was actually found to be invalid in October 2015. And this was replaced by Privacy Shield, which was intended, at least in theory, to be more robust. Now, until recently, the European Commission gave the US an adequacy decision limited to the extent of the Privacy Shield framework.
So Safe Harbor was knocked out in 2015, Privacy Shield knocked out now. So we've been there before, but been here before.
Yep.
Can you talk us through the background to Schrems 2 decision and the outcome of the case? And what I'll do is I'm just going to put up a slide just with some key points, I think, at the same time.
Sounds good. So Schrems 2 actually began with Max Schrems, who is an Austrian privacy advocate who decided to file a complaint about data transfers by Facebook Ireland to the US against the backdrop of the PRISM spying program and the Snowden revelations. This case, which was Schrems 1, ultimately ended up before the CJEU in October 2015, and the court struck down the Safe Harbor framework, and which was at that time used by around 4,500 companies, including Facebook, to transfer data to the US. As a result, Facebook switched to using the standard contractual clauses, and Max Schrems lodged a fresh complaint about the validity of these to protect data transferred to the US. This case was Schrems 2. So if we flash forward to July 16th this year, just a couple of weeks ago, and the Court of Justice of the European Union issued its decision in this case, and that decision declared the use of Privacy Shield framework invalid, but upheld the use of the standard contractual clauses as a compliant means of transferring data from the EU to the US, subject to some additional qualifications.
Okay, good. So what does that mean then in practice for companies that have been relying on Privacy Shield or indeed the standard contractual clauses to transfer data to the States?
Well, interestingly, the European Board of Data Protection indicated in their FAQs, which they published on the 23rd of July, just really recently, that the use of Privacy Shield alone to transfer data is now illegal. And I would also point out that they indicate that there's no grace period. So, you know, any business now using Privacy Shield alone from the 23rd of July, that's illegal. So those that have been solely relying on Privacy Shield will have to pivot to another solution, including by putting in place standard contractual clauses if they haven't done so already. Those that have been relying on the standard contractual clauses alone will now need to consider the second part of the Schrems 2 decision more carefully. And the court noted that the underlying transfer, which will be subject to the standard contractual clauses, should be assessed on a case-by-case basis to determine whether the personal data will be adequately protected in the context of that particular transfer. This is because standard contractual clauses will bind both parties to the clauses in relation to the processing of the data, but they will not bind any third parties that may access the data through, for example, national security laws.
Got it. So I think it's I think having standard contractual clauses in place is no longer enough in its own right. I think that's very similar to GDPR, where there's a real emphasis on transparency, openness, accountability. So I suppose you can't really treat standard contractual clauses as a box-ticking exercise anymore. You need to go through a bit more of an analysis to work out whether the transfer is indeed protected, and indeed the receiver is going to pay more than lip service to the standard contractual clauses in terms of being bound. And that would also apply to intragroup data transfers as well. Just wonder, can you give us an example of where maybe this may come to light? You know, where these issues might come to light.
Well, okay, let's take the example of Company A. So Company A has been using standard contractual clauses to transfer personal data relating to its staff to a company based in the US, which performs an outsourced HR function, for example. So what impact does this decision have on its operations? Well, the Court of Justice of the European Union found that US law, and specifically Section 702 of the Foreign Intelligence Surveillance Act, which permits US authorities surveillance of foreign persons located outside of the US, it found that it does not ensure an equivalent level of protection to that provided under GDPR. Therefore, Company A will now need to undertake a transfer impact assessment, under which it should consider whether the standard contractual clauses offer enough protection to the employee personal data, including sensitive personal data, to provide the level of protection guaranteed by the GDPR. So, against the backdrop of the US surveillance laws, Company A may consider that it should make use of supplementary measures, such as encryption, in order to ensure that the US law does not impinge on the adequate level of protection guaranteed by the standard contractual clauses.
Got it. Okay, so yeah, it's likely to have a quite big effect. So GDPR obviously applies across the EEA. What has the reaction been to this decision amongst data protection authorities across Europe?
So supervisory authorities across Europe have actually provided quite different guidance, which isn't always helpful. And they've taken quite divergent stances on the published decision, although I would note that it is their intention, at least in theory, to work towards a common position in the near future on transfers to third countries. Yeah. In the UK, the ICO has advised that no company should sign up to Privacy Shield from now on, but that those who are already signed up to it should continue to do so whilst they review their guidance in light of the decision. Now, I would point out this statement was released by the ICO on the 16th of July, and we're awaiting updated guidance from the ICO, considering that the European Data Protection Board's guidance was released on the 23rd, and that indicated that Privacy Shield is now illegal and that there's no grace period. The German response was perhaps the most interesting. At federal level, the BFDI noted that companies now need to put in special safeguards in place when transferring data to the US. At state level, the Berlin Supervisory Authority took a strict approach to the decision and ordered that all companies based in Berlin immediately transfer personal data previously stored in the US back to Europe, and mandated that all organizations using cloud service providers in the US should switch to European-based providers. Now, you can imagine that caused quite a bit of headache for companies based in or operating around Berlin in Germany. And I guess ultimately what this divergence shows us is that until we have clear and unequivocal guidance from the European Data Protection Board and other EU authorities, that the national supervisory authorities agree to interpret in broadly the same way, we're not going to know what the future landscape of data transfers to the US or any other third countries for that matter will look like.
Okay, so with Privacy Shield knocked out, I think it's fair to say that we're going to get a lot more familiar with standard contractual clauses for international data transfers from now on. Just thinking back, the current iterations of the standard contractual clauses, the controller to controller and controller to processor ones, have been around for quite a number of years, I think almost 20 years now, and they haven't changed. And they weren't changed for GDPR as well. So I think we know the European Commission has been working in the background and producing new standard contractual clauses for a while now, partly as a defensive measure to the Schrems case because of the potential challenge to their terms. So given the outcome of the Schrems case and the fact that the standard contractual clauses are still valid, there may be maybe not as much of a rush to get new ones issued, but I think the assumption is that the European Commission will issue these new updated standard contractual clauses shortly, and hopefully they will bake in the sort of transfer impact assessment requirements that you've mentioned already, and also hopefully some GDPR requirements which are missing from the current iteration of the clauses. But I don't think we've been told exactly when they're likely to be issued yet. I think the Commission's still working on those. One other hope, I think, is that we hope that the new clauses will also cover processor to processor transfers, and that relationship is not currently covered in the existing contractual clauses. And that would be useful where you have a processor in Europe who wants to transfer or share data with a sub-processor out with Europe. So that, I think that will be quite a useful addition to the armory going forward. So I think it's likely that when the new clauses come into play, they won't necessarily affect the validity of existing agreements and transfers, but who knows? And I think we need to watch this space a bit closely, because there could be further disruption when the new clauses come into play. And I think many businesses will rush to ensure that they update their agreements to ensure that the new clauses and the new measures are the ones that now govern data transfers going forward. So certainly plenty to think about there. So moving away from that, I mean, Hannah, just thinking it's been ages, absolutely ages, since we've been discussing Brexit. Can you remind us of some of the implications of Brexit on data flows?
But, you know, it was only a matter of time before the B word came up in this context. And I guess we were all sick and tired of hearing about Brexit back in 2019 and 2018. But I'm sure many of you like me would trade all the coronavirus and new normal chat in the world for a good old Brexit chat any day. So here we go. I guess at the end of the year, the UK is going to become a third country for the purposes of the GDPR. In relation to future transfers, this means that transfers from the UK to the EU can continue unimpeded, as the UK has decided that the EU has adequate data protection laws. However, transfers from the EU to the UK are likely to be affected, as the EU has not yet made a reciprocal finding that the UK has adequate data protection laws. Now, realistically, this decision will result in the UK kind of being caught between the US and the EU in terms of data transfers, because as of 1st of January 2021, the UK is going to have full autonomy over data transfers and could, in theory, re-establish a privacy shield type arrangement with the US. This would be greatly welcomed by the US, but it would put the issuance of an adequacy decision in favour of the UK at even greater risk than it is at present, because the EU would be worried about onward transfer of EU data subjects' data to the US. So the potential for the UK to set up a privacy shield arrangement with the US is just one of the reasons why an adequacy decision in favour of the UK is by no means guaranteed. Yeah. And whilst the CGEU did not rule on adequacy of the UK in this decision, it did rule on the adequacy of the US laws. And one of the deciding factors was the existence of far-reaching surveillance powers, like you mentioned before. Now, in the UK, we actually have a similar act. It's called the Investigatory Powers Act 2016, and that could actually be a major stumbling block in the route to gaining an adequacy decision. Now, without an adequacy decision going forward, costs of transferring data from the EU to the UK will rise, as the standard contractual clauses will be required for every transfer, and it is likely that businesses will need to consider supplementary measures in addition to that. So all in all, it's, I guess, not surprising that the UK government issued a statement indicating that it was disappointed with this decision, although I'd say that's maybe a bit of an understatement.
Okay, so just any top tips then for taking into account that the new decision and the Brexit angle?
Sure. So top tips. Well, organisations are going to need to review data flows first and foremost to countries outside of the EU and identify any high-risk data flows, which would include those to the US, and those that were based on the standard contractual clauses as the only safeguards being relied upon. Now, where the Privacy Shield alone is being relied upon, businesses should put in place either binding corporate rules, which can be used where a transfer is being made to a group company, or the standard contractual clauses, where the transfer is being made to a third party.
Yep.
In addition, where standard contractual clauses are being used, businesses are going to need to conduct a transfer impact assessment and look to mitigate any risks identified from that impact assessment, which should cover, the type of data being transferred, the sensitivity of data being transferred, and crucially, a sort of summary or a review of the national laws in the host jurisdiction, so the jurisdiction that the data is being actually transferred to. So any risks that are identified, such as the national surveillance laws, will need to be mitigated with some supplementary measures. Now, we don't know as of yet. We're still waiting on guidance from the European Data Protection Board as to what these might be, but we think one of them is probably going to be encryption. So, in terms of these supplementary measures, it's good to be keeping an ear to the ground and an eye on our blogs to keep up to date on guidance from the European Data Protection Board on the form of the supplementary measures that we can put in place. In relation to Brexit, it would be great to start preparing early. You can look to put in place binding corporate rules or intra-group data transfer agreements to protect the ongoing flow of data. And it would be good to just sort of look at your existing agreements with third parties in the EU with a view to triaging and updating them in time for Brexit. And that's that.
Thanks, Hannah. Some really good top tips there. Loads to think about, particularly if you have been relying on Privacy Shield, but also plenty to think about ongoing in terms of data transfers outside of the UK and outside of the EEA. Many thanks, Hannah. So let's move on now to look at the topic of email marketing. And if we've got time, we'll also provide a wee update on cookies and Adtech as well. So, Scott, do you want to kick us off with the discussion on email marketing?
Yeah, no problem, David. So I'm mainly going to talk to you today about regulatory issues in relation to email marketing. This involves sending promotional, advertising, or marketing emails to individuals, both B2C, or business to consumer, and B2B, business to business. With the spread of COVID-19 and the current economic climate, companies may now be more reliant on email marketing as a cheap and effective means of selling or promoting their goods and services to customers. In addition, at the start of this year, the UK's data protection regulator, the ICO, issued a new direct marketing code of practice, a draft version of their new direct marketing code of practice. This sets out the ICO's current thinking and interpretation of the law and practice in direct marketing and contains guidance on a number of key areas that are important for sending out marketing emails.
Good. I think before we crack on, I'll just maybe mention that we have the chat function on the so if there's any questions you'd like us to tackle at the end, please feel free to add those to the chat function, and we'll see if we can get to them at the end. So coming back to marketing, Scott, what are the key legal requirements then, would you say, for business to consumer email marketing?
So the GDPR applies to all forms of email marketing, but there are also some special rules that apply only to B2C marketing emails. The key legislation here is known as PECR. This refers to the Privacy and Electronic Communications Regulations 2003, which implement the EU's e-privacy directive. Unsolicited B2C email marketing is tightly controlled. This is because it's so cheap and it's free, and it's much easier than other means of sending out marketing communications, and there's a strong demand to prevent spam emails from being sent. The ICO takes active enforcement action against companies which breach the rules in this area, and other than data security breaches, it's currently one of the main areas for ICO enforcement and fines. Under PECR, you're only permitted to send out unsolicited direct marketing emails to a consumer if you've obtained either consent or if you comply with the requirements for what is called the soft opt-in. When we refer to consent here, this means the GDPR standard for consent. So the introduction of GDPR enhanced the requirements here, which means the consent must be freely given, specific, informed, and unambiguous. It's not sufficient anymore to rely on any form of implied consent, and it's also necessary to maintain records of consents for the purposes of GDPR compliance. And the soft opt-in, this is the one situation where consent is not required. So it's a set of particular circumstances that must be satisfied in order to rely on the soft opt-in. And this it can only be used if you collect an individual's email address in the course of selling them products or services, or negotiating with them for the sale of products or services. For example, a product inquiry form. Because it's related to commercial sales, it can't be used by charities, for example. However, at the time of collecting the email address, you must offer the individual the option to opt out of marketing, and then also include an unsubscribe option in each subsequent communication. And you're only permitted to use this to market your own similar goods or products. So because of a lot of these sort of different requirements must be met, some businesses take the more simple approach of just relying on consent. It's something we sometimes see.
Got it. So that, I think that sort of deals with sort of business to consumer marketing. Any differences with business to business practice?
Yeah, definitely. The position in the UK, at least, is much more relaxed for business to business email marketing. The rules under PECR don't apply to corporate subscribers, which includes company employees or representatives. So when you send it to a company employee's email address, so scott.mcgeachie@burnnesspaull.com, for example. However, it is still necessary to comply with the requirements of the GDPR when sending out any B2B marketing email to an identifiable individual. So the ICO has stated that it's possible to use legitimate interests as a lawful basis in this type of situation. However, in order to do this, you need to show that the way that you use people's data is proportionate, it has a minimal privacy impact, and people will not be surprised or likely to object to what you are doing. So it's not something out of the blue, it's totally unrelated to somebody's, industry, for example. And just as a general point, when sending out any marketing emails, B2C or B2B, you should include a link to your privacy notice in that email, and also include a link which makes it easy for individuals to opt out or unsubscribe from future marketing emails. Under the GDPR, there is an absolute right to object to direct marketing, and if an individual unsubscribes, you must add them to your unsubscribe list and make sure you stop sending them any further marketing emails.
So many businesses will be quite used to sending out email marketing. And so going back to the ICO's sort of code of practice, are there some key areas of guidance for email marketing, and also some examples of maybe any enforcement action in this area?
Yes. One of the key areas for email marketing is the guidance on what is referred to as service messages or transactional messages.
Oh, yeah.
This refers to messages that need to be sent out for the purposes of transactional, customer service, operational, or administrative type reasons. For example, this could include emails containing information about a current contract or a past purchase, including delivery arrangements, product safety, changes to terms and conditions, or changes to tariffs. The general rule is that these types of emails are not regarded as marketing, and therefore there is no need to check for consents or screen against unsubscribe lists before sending out, so you can reach a wider range of individuals. However, the risk, because of this, the risk is that some companies may try to sneak in some form of marketing or promotional messages to be provided to all their customers. The ICO has confirmed that if an email is sent out mainly for a transactional purpose, but it also contains even a minor marketing message, then the whole email will automatically be converted into a direct marketing email. In addition, the ICO has confirmed that a transactional email must be drafted in neutral language and must not be drafted in a way which is intended to promote further purchases or contract renewals in order to rely on this exception for service messages. The ICO has taken enforcement action in this area. One example is a fine issued against the Royal Mail. They were fined £12,000 for sending 300,000 emails containing promotional and marketing language without consent. The Royal Mail thought they were sending out a transactional email on tariff reductions, but they failed to use neutral language for this. They were using active promotional language and intending to get people to sign up for this rather than sort of a simple update. And therefore, they didn't obtain the proper consents or check against unsubscribe lists for this type of email. On the text messaging side, there was also a high-profile case against EE, where they were fined £100,000 for sending out 2.5 million text messages. Once again, they thought it was a transactional email to update them about things, but they also included promotional messages in that, and that meant that they were caught with the rules and they'd failed to obtain the consents, which led to a £100,000 fine.
So the fines are going up, it would appear. So does the code of practice include any guidance in relation to sort of buying in leads? I think that's quite a common practice, buying in marketing databases or leads, etc. Anything on that?
Yes, there is useful clarification of the rules for buying in marketing lists and leads. The key point in this area is that any buyer must conduct proportionate due diligence on the data vendor's acquisition of any marketing leads, including the source of the data, and also obtain records of any consents which have been collected from individuals. When you purchase a database of B2C marketing leads from a vendor, you can only use those leads for B2C email marketing if the individuals have provided a specific consent to receive email marketing from you. You have to be specifically named in the actual consent. Therefore, in order to ensure that you're named in the consent, you have to work with that vendor beforehand in order to ensure that there's an agreement in place where they go and effectively collect the consents for you to then enable you to send out marketing emails and rely on that marketing list. So it's not sufficient to rely on a vendor who's obtained a general consent from individuals, which permits email marketing from, say, all third-party partners. This fails to meet the GDPR standard for specific consent. A good example of this case is the example of Bounty, where a provider of support services to pregnant women and mothers. Bounty collected data on 14 million customers, but then also engaged in a form of data broking services, where they sold on data to some third parties for the purposes of email marketing, but without obtaining valid consents which were specific and freely given. They were fined £400,000 by the ICO, and one of the key breaches was that they failed to obtain consents that specifically named the key third parties who would then be sending out email marketing to the customers. Instead, they obtained generic consents which could not be relied on by the third parties for the purposes of email marketing.
Got it. So lots to think about there. I mean, a lot of businesses will use and sort of outsource the provision of email marketing to third parties. Does that sort of get you off the hook, as it were? Is there any issue in relation to using third parties for marketing purposes?
There is issues with using third parties for marketing purposes. The key point here is that PEGR applies to both the sender and also the instigator of the marketing emails. As such, if you instigate or encourage emails to be sent out on your behalf by a third party, you will then be responsible for compliance with PEGR, and this includes the requirement to obtain consents for B2C email marketing. Therefore, you can't just ask another third party to send out emails to their database and hope that that's okay, because you've not got any consents for sending your marketing messages to that database. Mm-hmm. A good example of the ICO taking action in this area is the case of Grove Pension Solutions. So Grove arranged for a third party to send out marketing emails to their database. They sent out approximately 2 million emails. However, the individuals listed in that database had no relationship with Grove and not provided any consents to receive their marketing emails. In this case, Grove did not actually send the emails and did not even hold a copy of the database of email addresses. However, they were held to have instigated the marketing messages, and therefore they were responsible for obtaining consents from individuals before arranging for their marketing emails to be sent out. In this case, the fine issued was £40,000.
Okay, yes, good to know. Yeah, during lockdown, I've been aware that there's been quite a number of new goods or services I bought online where the providers wanted to refer a friend, or there's an incentive to refer on to people in your network. Is there any information or good practice in relation to refer a friend schemes?
Yeah, this is actually a controversial point in the draft guidance, because refer a friend schemes are popular and commonplace for many businesses as a means of offering discounts and winning new customers in business. However, the ICO has applied its analysis of instigation of marketing emails to refer a friend schemes, and they have said that if a business instigates or encourages its customer to send marketing emails to their friends, then they are responsible for those marketing emails and required to ensure compliance with PEGR. However, this means it's not really possible for the business to obtain any form of consent from their customers' friends when they have no law connection or relationship with them.
Yeah.
So it'd be difficult to establish a lawful basis for operating a friend scheme according to the ICO's guidance. We expect that stakeholders will have pushed back strongly on this point, as this would undermine a standard business practice, and it's hoped that the ICO will provide additional guidance or clarification in the final draft, which would permit refer-a-friend schemes to continue. For example, one way of doing this would be to ask a customer to send a unique code or link to friends in order to benefit from the scheme, rather than a marketing message.
Good to know. Okay. I mean, it's clearly an area where there's a lot of interest in regulatory scrutiny. Where do you think we're going to get to in terms of the ICO's approach to enforcement and possibly, and fines, I suppose, ultimately? Where do you think that's going to get to?
Well, the ICO has been active in enforcing against breaches, especially in relation to B2C marketing emails and also B2C marketing generally. There's been an extensive number of cases over recent years. However, the fines have tended to be on the lower end of the scale compared to the GDPR type level fines. But this is mainly because the ICO deals with these fines under PECR, which, like the old Data Protection Act 98, is capped at fines of £500,000.
Yeah.
However, a breach of email marketing rules will also constitute a breach of the GDPR. If you fail to obtain consent when required to do so under PECR, it will not be possible to establish a lawful basis under GDPR. And based on that, we've started to see data protection authorities in other European countries issue GDPR-level fines for marketing breaches, including breaches of the email marketing rules. For example, last month, the DPA in the German state of Baden-Württemberg issued a fine of €1.24 million after a health insurance provider sent out only 500 emails without consent. In addition, earlier this month, the Italian Data Protection Authority issued a fine of €16 million against a telecoms provider after receiving hundreds of complaints about unsolicited marketing communications without consent. The ICO has been criticised for its lack of effective enforcement of GDPR, with a comparatively low level of fines being issued for GDPR breaches. In light of recent practice in Europe, there is a risk that the ICO may also move in the direction of GDPR-level fines for marketing breaches. And this would be one of the easier areas for enforcement by the ICO, as B2C marketing email, as the laws on B2C marketing emails is one of the few areas in data protection law where there are clear, bright line rules, and therefore it's easier for them to prove a breach of the law. So a key takeaway here is that it would be best to review email marketing practices in light of recent developments in order to ensure that you're complying with the latest law and guidance in this area.
Certainly, there's a massive difference between a few £1,000 fine and several million fine for these kind of activities. So I can see why that might be causing some alarm in some quarters. So we've dealt with email marketing, and I think why don't we just look now maybe at some updates on cookies, which is obviously something that the majority of businesses will use on their day-to-day websites. Can you give us a short maybe update on recent developments in this area, Scott?
Yeah, no problem. So as you may know, cookies are small text files that are placed on your computer by the websites you visit in order to help with understanding use of the website, in order to enable the website to function, but also in order to enable analysis, including for the purposes of targeted advertising. In the UK, the law on cookies is set out under PECR. The ICO issued guidance last year, updated guidance last year on cookies. This confirms that GDPR standard level of consent is required for most types of cookies, a freely given, specific, informed, and unambiguous consent. There is an exception where the cookies are strictly necessary. For example, those that are required in order to operate the website. For example, remembering items in a shopping basket, or in order to ensure security in the website. However, consent is needed for analytics cookies, which help to improve and analyze use of the website. However, the ICO has said it's likely to be low priority for enforcement in cases where these cookies are less intrusive and low risk. The higher risk issue is, or more controversial issue, is third-party cookies, where the website operator allows third-party advertisers to collect information about a user's browsing use of the website. And this is done for the purposes of building a virtual user profile and then ensuring that targeted advertising is provided to that user based on their recent activity. So this is the sort of controversial area we see here. We also see there's also the complaints about cookie banners and how they can create fatigue for users of websites. And there's also an issue in relation to cookie walls, which prohibit access unless the user consents to cookies. However, the European Data Protection Board has recently issued guidance which said that these type of cookie walls are unlawful as they do not constitute a form of freely given consent.
So like many others of data privacy, there's a move towards being more transparent and open with users, and particularly letting people know, what data is being collected about them when they visit various websites, etc., and having that transparency and that very, very upfront information. So, I mean, moving into this new area, has there been any enforcement action in this area? What are the regulators doing?
Well, there are hundreds of complaints about cookies submitted to the ICO every month. However, to date, the ICO has not actually fined MD for breaches of the cookie requirements. Instead, our understanding is the ICO deals with the complaints through standard case handling procedures and provides recommendations to businesses to address issues in practice. However, at the European level, we have seen fines issued by data protection authorities in Europe in this area, for example, in Spain, Belgium, and the Netherlands. However, these are usually lower level fines for breaches of cookie legislation, ranging from around 15,000 to 30,000 euros.
So the regulators are sort of still maybe bringing themselves up to speed to really look at this area, but nevertheless, it's an important area, and I'm sure it will be an area where there's increased scrutiny. So, on that topic, is there any proposed law reform in the area? What's next in the world of cookies?
Well, cookie law reform is currently the subject of debate under proposed new European legislation, the e-privacy regulation. There's a proposal currently on the table from the EU presidency, Germany, to allow legitimate interests to be used as the lawful basis instead of consent in certain circumstances. However, this is controversial as many privacy campaigners still back reliance on consent. However, in practice, it is arguable that recent decisions taken by the operators of the major browsers may have a bigger impact on the evolution of cookies than any legislative changes. In particular, Apple's Safari browser and also Firefox now block the use of third-party cookies by default. And similarly, Google's Chrome browser has announced that it will phase out the use of third-party cookies within the next 2 years.
Okay, all this chat of cookies is making me hungry, but I think we'll move on. I wonder, we did say we'd mention Adtech briefly, so I just wondered if you are able to give us a quick update on the Adtech industry and what it means and what it means, what changes maybe afoot in the future.
Well, yes, the ICO is currently carrying out an investigation into the Adtech industry. And this refers to an investigation into the operation of what's called real-time bidding. This involves the use of cookies to build profiles of individuals' interests based on their online behaviour across different websites. There's then an automated bidding process that takes place, with advertisers bidding for the right to display targeted advertising to a specific individual when they download a web page. And this entire process takes place within milliseconds. Now, back in 2019, the ICO issued a report on this area, which identified a wide range of GDPR breaches and PECA breaches, including failure to obtain consent for the use of cookies and widespread unlawful processing of personal data, including failure to obtain explicit consent for processing of sensitive personal data, for example, health data that is collected on identifiable individuals when building a profile of their interests. When the ICO published its report, it initially gave the industry 6 months to address these issues. However, after this period elapsed, the ICO published an update which stated that many in the industry still had their heads in the sand on this issue, and therefore the ICO would consider its regulatory response. However, this is the investigation has been paused or suspended following the outbreak of COVID-19, and the ICO has stated that they are suspending it until further notice. And last week, they admitted this might not resume until 2021. So there's sort of a reprieve for the Adtech industry in this case.
Yes, the Adtech review has been another victim of COVID over the last wee while. So, okay. Well, look, there's plenty to think about there in terms of email marketing, cookies, and some changes afoot in Adtech. And I think it's fair to say that online regulation and practice is likely to continue to feature highly in our future updates. So thanks, Scott, for going through that at a reasonably high level. So in our final section of our regulatory update, we wanted to look at data sharing. So hi, Sarah, sorry for keeping you waiting to the end, but I just wonder if you want to kick us off on our regulatory update on data sharing, but provide a brief overview of data sharing.
Yes, of course. Thanks, David. So data sharing usually means disclosing personal data to third parties outside your organisation, but it can also cover the sharing of personal data between different parts of your own organisation or other organisations within the same group. So the Data Protection Act 1998 defines data sharing as the disclosure of the data by transmission, dissemination, or otherwise making it available. However, the Act did not provide any practical guidance on how to share personal data. So the 2011 Data Sharing Code plugged that gap and clarified that data sharing more accurately meant the disclosure of data. So the term data sharing can therefore cover a wide range of activities, from data recording, data deletion, data transmission to big data analytics, where personal data is disclosed to another organisation, for example, outsourcing, buying and selling a database, mergers and acquisitions, or where personal data could be shared with another part of the same organisation, for example, between HR and another internal business function. So data sharing can take place in a routine scheduled way or on a one-off basis, for example, in an emergency situation. So the 2011 code provides organisations that share personal data with best practice guidance, and until the ICO issues an updated data sharing code, businesses may continue using the 2011 code as a guide.
So 2011 code seems a wee bit out of date, particularly when we've had a massive change in terms of GDPR and all the various issues we've talked about earlier. Is there any indication as to when the ICO are likely to be issuing an updated code of practice in this area?
Yes, so the ICO are currently working on updating their data sharing code and launched a call for views in August 2018, seeking input from people and various organisations such as trade associations. And we believe that the updated draft code will explain and advise on changes to data protection legislation where these changes are relevant to data sharing. And it will address many aspects of the new legislation, including transparency, lawful bases for processing, the new accountability principle, and the requirement to record processing activities. So the draft code is now available on the ICO's website, and we can potentially come back and revisit the updated code in future sessions when we hear any further updates.
Sounds like a good plan. So, you know, we have the 2011 code at the moment. What are the consequences then for businesses if you don't comply with the code?
So compliance with the 2011 code is not mandatory and not legally binding. It doesn't impose any additional legal obligations over and above the requirements included in the data protection legislation. However, you should bear in mind that if you don't comply with the guidance in the code, you may find it more difficult to demonstrate that your data sharing is fair, lawful and accountable and complies with the GDPR or the DPA. So if you process personal data in breach of the code and this results in a breach of the GDPR or the DPA, the ICO can take action against you and impose significant fines, as we touched upon in our previous webinar.
Right, so it's good to get familiar with the code as it stands out, perhaps the draft as it progresses. So if you were to enter into an agreement to share personal data on an ongoing basis, what would you regard as the key considerations to take into account?
So the first point to consider in this situation where you're dealing with systematic data sharing is whether the sharing is justified. So what is the sharing meant to achieve? Have you assessed the potential benefits and risks to individuals of sharing or not sharing? Is the sharing proportionate to the issue you're addressing? Could the objective be achieved without sharing personal data? Then the second point to address is, do you have the power to share? So when thinking about this question, consider the type of organisation you work for, the nature of the information you've been asked to share. For example, was it given in confidence? And any legal obligation to share information, for example, a statutory requirement or a court order. Then if you do decide to share, the ICO recommends that you have a data sharing agreement in place, detailing what information needs to be shared, what organisations will be involved, measures to ensure adequate security, and processes to ensure secure deletion takes place.
So that's often it's often missed that it's the importance of putting a data sharing agreement in place in those scenarios. So that's a good point just to bring up. So looking at a slightly different scenario then. So what if you share personal data in a sort of a one-off circumstance? It's a one-off transfer. It's not an ongoing thing, but it's just a one-off activity.
So if you're dealing with a one-off request, probably the first thing that you should consider once again is, do you think you should share the information? Do you have concerns that an individual is at risk of serious harm? Do you need to consider an exemption in the DPA to share? As I've just mentioned, the second point to then address is, do you have the power to share? And then if you do decide to share, you should consider what information you need to share, only share what's necessary, and also consider how the information should be shared. So noting that information must be shared securely, and you should make sure that you're giving the information to the right person.
Yeah, so all of that should be set out in an appropriate contract that deals with all of that, and you've gone through the risk analysis. So lastly, any top tips, I suppose, for data sharing and best practices for businesses?
Yep, so when considering sharing data, you must assess your overall compliance with the data protection legislation. And as a first step, you should decide whether you need to carry out a data protection impact assessment. So the ICO recommends that you consider following the DPIA process, even where you're not legally obliged to carry one out. In respect of data standards, you must always share personal data fairly and in a transparent manner. You must be able to identify at least one lawful basis for sharing data from the start. And it's also therefore recommended that organisations appoint someone within the business involved in the data sharing to take overall responsibility for information governance. It's also good practice to have a data sharing agreement in place, which sets out the purpose of the data sharing, covers what is to happen to the data at each stage, sets standards, and helps all the parties to be clear about their respective roles. Train your staff so that they know who has the authority to share personal data and in what circumstances this can take place. The focus of the training should be enabling staff to make informed decisions about whether or how to share data and how to treat the data they're responsible for. You should also consider reviewing your data sharing agreement on a regular basis, because changes in circumstances or the rationale for the data sharing may arise at any point. And the ICO also maintains a public register of data controllers, and each register entry includes the name and address of the data controller and details about the types of personal data that they process. So all data controllers should ensure that the relevant details are added to the register as well. So that's some of our top tips for data sharing best practices. And I think if anyone has any questions now, we would be happy to help answer them.
So we've covered a lot in this session, and I think you made an important point where the data sharing agreements, quite often they are a snapshot in time, whereby the point the agreement's put in place, but data flows aren't like that. They are constantly evolving and changing. So I think your point about sort of reviewing where the organisations sit in relation to data transfers and data flows is really important. So that's a good point. So we do have a couple of questions coming in. Can I maybe come to you, Sarah, first of all? Are there any additional considerations for companies in the public sector to consider when sharing data?
Yes, so additional considerations arise for public sector bodies as they can only act within their statutory duties. So your starting point in deciding whether any data sharing may proceed should be to identify the legislation that is relevant to your organisation. So the relevant legislation will probably define the organisation's functions in terms of its purposes, the things that it must do, and the powers which the organisation may exercise in order to achieve those purposes. So it's necessary to identify where the data sharing in question would fit, if at all, into the range of things that the organisation is able to do. So broadly speaking, there are three ways in which it may do so. Firstly, express obligations. So occasionally a public body will be legally obliged to share particular information with a named organisation. Secondly, sometimes a public body will have an express power to share information. And thirdly, often the legislation regulating a public body's activities is silent on the issue of data sharing. And in these circumstances, it may be possible to rely on an implied power to share information derived from express provisions of the legislation. So to decide if you can rely on an implied power, you'll need to identify the activity to which the proposed data sharing would be reasonably incidental, and then check that the organisation has the power to engage in that activity.
Got it. I think we've got room for one more question. There was another question. We mentioned binding corporate rules as a mechanism for the sharing of data, and there's a private question coming, which is basically, I think the scenario is the organisation's currently looking at putting in place binding corporate rules for the intragroup sharing of data. And the question is, do you think the Schrems decision will result in further delays in relation to the review of that, the binding corporate rules? And I think, unfortunately, yes is the answer. There's probably a lot going on with regulators at the moment and trying to get their heads around the Schrems decision. So I think if you are in the process of looking at binding corporate rules as an alternative to standard contractual clauses, or indeed privacy shield, there may well be a period of reflection before these are put in place, not least because the regulators are also looking at what the standard contractual clauses and other mechanisms might look like going forward. So I think lots to think about there. I'm hugely aware that we're coming up to the hour at 11 o'clock. We have cantered through quite a lot of different areas there, so thank you for your patience. As I said at the outset, I think it's quite possible that we could have spent an individual hour looking at each of these areas individually, and we may well do so in the future. So if you have any questions that we haven't been able to answer, please feel free to contact us or contact your usual Burness Paull contact in the usual way. And thank you for being with us. Enjoy the rest of your day.